Depositions are like conferences or small meetings. The other side who has subpoenaed you will generally hold a deposition at their own law offices. This will usually happen in a small to medium-sized conference room because there will be anywhere from 4 to 20 people there. Each side has to have at least one attorney present. There will often be other attorneys there for specialized purposes, especially in a complicated case involving multiple litigants. Usually, each side will bring 1 to several interested people, including the clients who originally hired the attorneys. Sometimes an opposing expert and 1 to several employees of the opposing client's company will be at your deposition. They will be there to further check the accuracy of what you have to say. Finally, the court reporter will be there. He or she is a licensed professional who will type in legal shorthand a recording of every word that is spoken during the deposition proceedings. Occasionally, a deposition may be held at or near your own office or home. This might happen if you live a distance away from the attorneys and your busy schedule makes it difficult for you to get away for your deposition. Do not offer your office or your home as the site of your deposition. All other files and computer contents at those sites may be discoverable, and you may be expected to allow access to them during your deposition. Let the attorneys rent a hotel conference room for the deposition. After you arrive at your deposition, and before it begins, the opposing attorney will ask if you brought your case file with you. Not only should you have brought it with you, but you should have read everything inside it to refresh your memory. The opposing attorney will ask questions about anything that he finds inside your entire case file, and he's entitled to do that. Also, you should have shown that entire case file, briefly at least, to your attorney before arriving at the deposition site. If your file has any privileged information in it, your attorney has the right to remove it before the other attorney has the opportunity to copy it and ask you questions about it. Your file folder should only contain information that you relied on to form your opinions. It can have notes, invoices, time logs, and miscellaneous documents that you collected and considered. However, you should not take a laptop computer or an attaché case or any other documents with you. The opposing attorney could ask to look at all of those things. Opposing attorneys will generally start by copying your file folder and its contents, so they can refer to the copy during the deposition and ask you questions about the content. You can refer to your original papers, referencing exact contents during questioning. If your file is extensive, it may take a while to make this copy, and the opposing attorney may begin the deposition without the copies, or even your originals being available. When they do this, they will usually begin with an innocuous set of questions that address your background, experience, and education. Obviously, you should have a good handle on those things already, particularly dates of schooling, licenses, additional training, and employment. An important point here is that you will not always have your CV in front of you to quote from or to refresh your memory about your own background. However, if you do not remember the details and dates, you should say so, and say that you would like to wait until your CV and case file have been returned to you. You do not want to omit entering into the record important facts about your background, experience, and credentials, just because you may not remember all of them. An important reason for asking about your background is to validate that you have the training and specialized knowledge of your field that is required to qualify as an expert witness. So a most important tactic is that you should review everything in your case file, which should include an updated CV, before you arrive at the deposition. Once the deposition begins, the court reporter will swear you in, just as you see on television in a trial. At that point, the opposing attorney will usually begin the proceedings by asking you for your full name and ask you to spell it for the record. If you are new to testimony, he or she will surely offer you a brief explanation of the process and then ask if you understand and if you have any questions. Obviously, ask any questions that you do have at this point. After you have been deposed several times, the opposing attorney will probably comment on that fact and attempt to skip over any lengthy explanations of the process. Some attorneys and experts suggest that you ask the opposing attorney to review explicitly the ground rules that you should know, even if you have been deposed many times in the past. The valid reason for this is that the rules can change from time to time or from state to state. If the deposition proceeds and your case file has not yet been returned to you, you may not recall all the details needed to answer opposing attorney's questions. Please do not work from memory. Simply say that a necessary piece of information is in your file and you will be glad to address a particular question when your file is returned to you. Let's discuss the job of the court reporter for a moment. Over the course of the deposition, there will be occasional breaks that are agreed on or that are asked for by either you or one of the attorneys. When these breaks are agreed on by both attorneys, the court reporter will stop typing. At that moment, and not before, you are off the record. When the proceedings continue, the court reporter will continue typing and you will be back on the record. The court reporter has another responsibility. The court reporter has the task of marking and identifying each new piece of evidence. This happens before you begin answering questions about the contents of that new evidence. The opposing counsel can either bring a new document or exhibit to the deposition, or he may introduce into evidence a document that you brought as part of your case file. There will be times during the deposition day when you are asked a question that is unclear. If the question is not clear because the attorney's phraseology is unclear, you can tell him so and ask him to rephrase the question. If, however, the question was complicated and you just lost your concentration, which can happen from time to time, don't let that bother you. But don't admit that you lost your concentration. Just ask the court reporter if they would reread the question for you. If at other times the attorney asks you a question that you recall being asked a while earlier, you can actually ask for the previous question and answer to be reread to you. If you use this request of the court reporter too often, it may be time to take a break.